Do not mess with Disney.
I mean, who knew that the same company behind the adorable little mouse cartoon and some of our favorite childhood movies had claws like these? Hey, I'm Josh Stanford. I'm America's attorney, and like you, I've been hearing all about the chess match between Governor Ron DeSantis and Disney for months and months and months. Well, Disney just put DeSantis in check by dropping a new lawsuit containing 5 claims for violations of Disney's rights. We're here today to break down the allegations. Now, this battle began over a year ago, back in March of 2022. The entire story is laid out in the first 46 pages of the 77-page lawsuit. A bit of light reading before bed. Or you can just stick around for the next 2 minutes while I recap it. Okay, this all started over House Bill 1557, which was signed into law on March 28th, 2022. This law prohibits discussion in the classroom about sexual orientation or gender identity, and it requires school districts and their boards to adopt procedures that basically require school officials to notify parents of their child's specified information. If a school district is found to have neglected to notify a parent about their child's specified information, the law opens up the school district to the liability of litigation. Now, in a nutshell, if a student confides in a teacher or a guidance counselor, they have no choice but to notify the parents about what they're told, or the school could be sued. This bill received major backlash from many different sources, but the one that Governor DeSantis seemed to take most personally was Disney's statement proclaiming that the bill, and I quote, should never have been signed into law, and that the company was committed to supporting the national and state organizations to achieve the annulment of the law. Before we go on, let me say as a sidebar, the purpose of this video is not to debate HB 1557. We're here to discuss the rules of the game, meaning the claims made in the lawsuit, none of which have anything to do with the legality or morality of HB 1557. Now, let's get out of this. Sidebar. Disney's public criticism of HB 1557 set off a tense back and forth between Disney and DeSantis that lasted months. Governor DeSantis was set on proving to the world that Disney didn't run Florida, and Disney was set on making sure that their business plans weren't going to get ruined by a mini tyrant. Governor DeSantis's big revenge plot turned out to be the dissolution of the Reedy Creek Improvement District, which used to oversee about 25,000 acres of land and provide services like fire protection, flood control, waste disposal, and maintain all public roadways and bridges. Wait, what do you mean you never heard of the Reedy Creek Improvement District? It's a special use district that is functionally a government body for limited purposes. The RCID used to be made up of a board that was elected by the landowners, which is primarily Disney, until DeSantis slapped a new label on the district, the Central Florida Tourism Oversight District, you can't say that very fast, and switched out the board with people that he handpicked. The change didn't come immediately, and Disney did not hesitate to use the intervening time to their advantage. Before the board was switched out, they, Disney, in an apparently totally legal manner, executed 2 contracts, a development agreement and a declaration of restrictive covenants. In combination, these 2 contracts maintain Disney's control over the growth and planning of their property and the aesthetics of the buildings in the district. Now, they didn't do this secretly. They appear to have published notice in the Orlando Sentinel, which for you young people is a newspaper, and for you really young people, a newspaper is a thing that used to exist, on 2 separate occasions, and they had 2 public meetings about it. It appears to have been done all out in the open. Now, once the board came into power, they realized that they had been played, and not just a little bit, like got played a lot. And they immediately sought to void the contracts by passing Senate Bill 4C and House Bill 9B, which leads us finally to the real subject of today's video. Disney has sued Governor DeSantis for violating the Contracts Clause, the Takings Clause, the Due Process Clause, and 2 counts of violating the First Amendment just for good measure. So let's break them down. The Contracts Clause protects individuals and businesses from the state's intrusion on and invalidation of private contracts. Disney is claiming that DeSantis violated this fundamental right by revoking a valid contract between the RCID and Disney. When the switch was made from the RCID to the Central Florida Tourism Oversight District, The state declared that the new district would retain all the RCID's financial and contractual obligations. Any contracts before the bill of the CFTOD went into effect, which is still off in June of 2023, would remain in effect. Both the development agreement and the declaration of restrictive covenants were executed on February 8th. Disney claims in the lawsuit that because the legislature's decision to void both contracts was targeted at a specific business, namely Disney, and voiding the contracts doesn't serve an important government interest, it violated the Contracts Clause. The next charge is a violation of the Takings Clause. The Takings Clause in the Fifth Amendment states, "Nor shall private property be taken for public use without just compensation." Disney is claiming that not only can the contract itself be considered a form of property, but both the contracts involve the rights and the use of specific property. By voiding these contracts, the DeSantis administration deprives Disney of the rights to the private property, and as far as we know, no compensation has been offered. For these reasons, Disney is alleging that DeSantis and the rest of the defendants violated the Takings Clause. Next, Disney claims that the Due Process Clause was violated. The 14th Amendment says, "No state shall deprive any person of life, liberty, or property without due process of law." This means that the state government has to follow certain procedures before they deprive a person or a corporation of protected life, liberty, or property. Disney claims that because the CFTOD cannot show that the cancellation of the contracts was to advance any legitimate state interest, as opposed to just punishing Disney for their statements, they violated the Due Process Clause. And now we get to the juicy stuff. 2 counts of violating the First Amendment. Now, I don't need to explain to you the First Amendment. So let's just jump right into the allegations. First, Disney makes clear that their original statement condemning HB 1557 was protected speech. And it was. It was political speech. It was very political speech. To be clear, what Disney said was that they would work to have the bill overturned. They were committing to play the game the way that the game is played. But why 2 separate counts in the lawsuit? Disney claims DeSantis and his administration violated the First Amendment once by voiding the development agreement and the declaration of restrictive covenants, and a second time by replacing the RDIC with the CFTOD in the first place. The lawsuit quotes DeSantis saying that the board would meet to make sure that Disney is held accountable. Comments like these, along with a lack of a rational basis to invalidate the contracts, led Disney to file the lawsuit. The second allegation of retaliation and the First Amendment violations is the original act of reconstituting Disney's governing body and structure to be the CFTOD. Again, Disney quotes DeSantis and other legislators in this section after already including several quotes in the introduction and factual background section of the lawsuit. These are comments like, "You kick the hornet's nest, things come up." And I will say this, you got me on one thing. This bill does target one company. It targets the Walt Disney Company. And that was from the Florida rep who introduced the bill to dissolve the RCID. And Governor DeSantis' own statements that he was fighting back for Disney's criticism of HB 1557. And this statement here from Senator Broxton, "We join with the governor in saying it was Disney's decision to go from an apolitical, safe 25,000 acres and try to be involved in public policy. We're saying you've changed the terms of the agreement, therefore we will put some authority around what you do." Disney included in its lawsuit a description of the strange circumstances that led to the passage of the bills that replaced the RCID. This includes adding the bill to a special session despite there not really being an emergency that would explain the rush treatment, the bill being brought in the first place after the RCID had been existing peacefully for decades, a lack of debate in the House, no time for stakeholders to conduct their own analysis, and the months-long wait for a concrete plan to execute the dissolution of the RCID. Now, for these reasons, Disney believes both actions were taken for the sole purpose of retaliating against Disney for speaking out against House Bill 1557, which constitutes multiple violations of the First Amendment. Disney's key claim that the bills intentionally targeted them as punishment for political speech, These can hardly be contested. If DeSantis and his operatives were conspiring to violate Disney's rights to engage in protected speech, instead of secretly gathering in an abandoned warehouse, they basically live streamed their meeting from the steps of the Capitol. I mean, publishing a book in which you document how you're turning the screws on your cultural and political opponent? Standing on the floor of the legislature and declaring this law targets Disney? All that stuff is very brazen. But is it illegal? The answer is simpler than you might think. Heck yeah, it's illegal! For real! I mean, I like close calls. Because I'm a lawyer, I love to say, well, it depends. But this is clown. Let's go back to the beginning. What Disney said is that they don't agree with the cultural vision that underscores HB 1557, and they wanted to do what they could to overturn it. That's their right. That's everyone's right. You can lobby, campaign, file lawsuits. Hey, it's America. Let's sue. The idea that the government would turn against you and start trying to punish you for exercising your political rights, well, that's just not going to play well in court. And ultimately, that's where we are now. We're in federal court in the Northern District of Florida. That means if the justice system works like it should, that we will get a legal ruling from a judge, not a political ruling, which is great for both sides. Both sides? How can they both win? I'm glad you asked. Assuming that the judge has even a passing familiarity with the U.S. Constitution, Disney wins this case with very little effort beyond what went into writing the complaint. And that's not really a loss for DeSantis and his administration, because ultimately Florida wants and needs the economic benefits that come from having Disney there in Central Florida and bringing in that tourism and that cash. So that's a win for DeSantis. But there's another win for the governor. He can claim that the reason he lost is that the judicial system is rigged, that it's unfair, that the courts always rule in favor of the liberals. That's a common theme from Republicans. The courts are supposed to be apolitical and designed to rein in the other two branches of the government. So that's what the courts are always doing. Then the court system is working. And if DeSantis gets to wave the loss in everyone's faces and try to garner support from his base, well, then that's okay too, because that's a common thing for politicians to do these days. The board recently decided to countersue to uphold their decision to void the contracts that Disney created with the previous board. Now, neither party appears to be backing down, so we can all just buckle in for the ride. But I'd like you to drop your pro se opinion down in the comments below. I'd like to know, do you think Governor DeSantis violated the First Amendment by taking over the board and voiding the contracts? Who do you think the judge will rule for or against? Let me know what you think. And then after that, head over to these great breakdowns by me, America's attorney. I will see you soon. Bye.